Either.
I'm sorry, who do we have? What? All right, we will call the state of Wisconsin versus Samuel Clay. It's 26 CF 1533 appearances.
ADA Bridget Cook for the state.
Samuel Clay appears in person in custody by student attorney Caroline Scott under the supervision of attorney Anderson. We have received a copy of the complaint and waive its reading. Mr. Clay is eligible for public defender services and number 2. Okay, and the address is correct.
Great, I'll make findings of probable cause. We get a not guilty plea entered to the misdemeanor. The public safety assessment recommends modest cash bail. State's position on bail.
State is recommending $2,000 cash. Conditions would be a ban from the grab and go and tobacco deals, both on East Washington Avenue in Madison. The reason for the cash request is his history of missed court appearances in the past 5 years and the potential penalty he's facing. I'm seeing a failure to appear on March 10th, 2025, April 23rd, 2025, and January 3rd, 2023, a couple others in 2023 and 2024, and then in Sauk County case 23 CF 318, a failure to appear on 12/12/23 and 10/9/23. The state believes that some cash is necessary to ensure his appearance, and the amount of cash is in line with the potential penalties he's facing.
Great, and Ms. Scott?
Your Honor, we have received a copy of the PSA report that does suggest modest cash bail. We'd be asking for a signature bond, or in the alternative, a much lower amount of cash than the state is suggesting. Mr. Clay is indigent and he is unable to post any amount of cash right now. In addition, he's been a Madison resident for 30 years. He is unemployed and lives on retirement as well as food bank services. And although he has some spotty appearance history in his past, it seems like some were due to transportation to Sauk County, and he has appeared out of custody in the past. And in addition, he informed me that he has recently suffered a back injury as well, which was contributing to some of his issues with appearing.
All right, I don't see it as a signature bond case. There's too extensive a history of failing to appear. I'll set $1,000 cash bail, order a ban from the grab and go and a ban from tobacco deals locations. And what about time limits?
We do want. Okay.
Leave them.
Oh, leave them. Yeah, that's what I thought.
Okay, we'll
Yeah,
get
we'll
it set
keep them.
within the
Bruce.
next 10
Thank you.
days for a prelim, and we are adjourned.
How much is
It smells like video. That's not right. Okay, who did you just call?
I missed it too, sorry.
I find out.
Who's that? HALBERSMA? HALBERSMA? HALBERSMA?
Good afternoon, sir.
Good afternoon. We'll call the state of Wisconsin versus JAROD HALBERSMA, 26 CM 1619 appearances.
ADA Bridget Cook for the state.
Good afternoon, Attorney Michael Covey. I'm making a special appearance today for Mr. HALBERSMA. I was his attorney for the other cases mentioned in this criminal complaint. I do have a copy of the criminal complaint. I would waive its reading. My understanding, the address is accurate.
Okay. And Mr. HALBERSMA, you can either hire Attorney Covey, or if you have him for a county appointment or public defender appointment, you'd need to reapply for that process. We'll make sure that you have that information in case you need it. We'll make findings of probable cause and enter not guilty pleas. State's position on bail.
State is recommending $1,500 cash bail, no contact with Michaela S.H. That's spelled Micayla. The state acknowledges that he turned himself into the Dane County Jail and hasn't missed court, but he did plead guilty to 3 separate counts of battery and a misdemeanor bail jumping against the same victim just on June 23rd, 2026 for deferred prosecution. And then the next day he was charged with another domestic incident and accused of battering the same victim again a few weeks later. In these incidents, he was ordered not to have contact with her. And so under the Act 3 lens, the state believes that cash is appropriate to protect the victim. And also his history on bail shows that he needs some cash incentive to comply.
And Attorney Covey.
Thank you. I do have to acknowledge that this does concern the same victim or the same alleged victim that I represented JAROD on in 2 previous cases. I would note, and counsel's correct, JAROD was definitely not a flight risk. He always appeared at court prompt and on time. He was always prepared for all of his meetings with this attorney. I recognize the frustration that the court might have that he's having allegedly continued contact with the victim. I would ask for a smaller cash bond. I would note that Mr. HALBERSMA does have stable residence. He does have a job, which if he does not attend the job on Friday, he could lose it. He did make himself available to law enforcement on Sunday. From my understanding, he turned himself in without any kind of incident. And I can state as an officer of the court that I was in contact with JAROD at that time. And he had made it very clear to me that he was going to turn himself in. For those reasons, I would ask for a $300 cash bond for this case. Thank you.
All right. Well, I think he gets credit for having turned himself into jail. The other stuff is not really in his favor. He's entered pleas to multiple batteries. He could be held without bail in those particular cases at this point. And it's a pretty good Act 3 argument at this point. I'm going to set a little bit less cash than the state's asked for, giving him credit for having turned himself in. But my main concern here isn't that he's going to fail to show up in court. It's an Act 3 analysis at this point. I'm going to set cash bill at $1,200. I'll order a no contact direct or indirect with Michaela S.H. and we'll be adjourned.
Thank you.
Next is Mitchell, Tyler Mitchell, Thanks, everyone.
Okay.
Thanks.
Good afternoon, you're on. Can you hear me all right? Or do I have to get closer?
We can hear.
Okay, sure.
We'll call the state of Wisconsin versus Tyler Mitchell. It's 26 CM 1614 appearances.
Bridget Cook for the state.
Tyler Mitchell appears in custody via Zoom by student intern Caroline Scott under the supervision of Attorney Anderson. Mr. Mitchell, have you received a copy of the complaint?
I had.
He has. Okay,
Yeah.
and is the address okay? And is the address correct on the complaint?
No, I don't. I've said this ad nauseum. This isn't where I live. But it's never been changed. It doesn't get changed each and every time, it's just the same thing.
Okay, what would you like to use for an address?
I don't really have one right now, so I live on State Street.
Is there a shelter or someplace that you stay at that you can get mail or the job center?
No, I just sleep on the street.
Okay, well, I guess that's why the address hasn't been changed in the other cases
Yeah,
and
most likely.
continue to use this address. Right, I'll make findings of probable cause. We'll get not guilty pleas entered to the charges. There's a public safety assessment report recommends moderate cash bail. What's the state's position?
State is recommending $500 cash, a ban from the Memorial Union, and no contact with David H. Mr. Mitchell was released on a signature bond for 26 CM 616 and then went back to the banned area near the library and picked up 26 CM 651. He got a $250 cash on 26 CM 651. And then it was reverted to a signature bond on July 2nd. He's causing a disturbance again in the same area and resisted the officers when they tried to arrest him.
I did.
He's already out on
So,
two.
Mr. Mitchell, you can't speak while other people are speaking. It makes it very hard for us to make a good record. You can continue.
He's out on two cases while this happens, and had bench warrants issued on December 3rd, 2024, April 21st, 2025, and May 27th, 2026. So some cash seems necessary at this point.
Great. And Ms. Scott?
Yes, Your Honor. I don't have information about whether or not Mr. Mitchell is eligible for public defender services. I realize I didn't address that. But I do want to note that he has stated that he's homeless. Oh, actually, I'm sorry. I think he may be eligible. He is represented by a public defender on his other cases. Sorry. He's homeless, so he is indigent, making any amount of cash difficult or near or impossible for him to post. In addition, the facts of the situation here don't seem to warrant cash bail. He was refusing to leave the Memorial Union and had an interaction with police officers there. I also think there's reason to believe that there are some mental health concerns here that the court should consider when setting bail.
All right. So first, Mr. Mitchell, I'm going to have the deputies make sure you get the public defender info. You got to reapply in every case. It's not clear to me whether you have already applied in this case. So give them a call to make sure that you can get a lawyer on this case as well. The appearance history is concerning. He's violating specific conditions of bail. He's got a resistive history. Here we are on case number 3. I don't see him as a better bail risk than when he had a $250 bail in an underlying case. Obviously, that may have been too much for him to post because it got modified to a signature bond, but I see it as a cash bail case. I'll set $300, order a ban from the Memorial Union, and no contact direct with David H. We are adjourned.
Going is next, Timothy. Going.
Right. We'll call the state of Wisconsin versus Timothy Goen. It's 26 CF 1531 appearances.
88 Bridget Cook for the state.
Timothy Goan appears in person in custody by Student Attorney Caroline Scott under the supervision of Attorney Anderson. We have received a copy of the complaint and waive its reading. Is this the best address for you? Okay, and the address on the complaint is correct. And Mr. Goan is not eligible or does not want public defender services and has a private attorney.
Okay. They've given you the public defender info in case you can't retain private counsel after today. I'll make findings of probable cause and are not guilty pleas to the misdemeanors and state's position on bail.
State is recommending $5,000 cash in this case, conditions of no operation of a motor vehicle at all, and no use or possession of alcohol. Mr. Goen was resisting and uncooperative throughout this entire interaction with officers, and for that reason alone, the state believes that some cash is necessary. I would say also the no operation of a motor vehicle is given the seriousness of the crash that occurred.
Right, and Ms. Scott?
Your Honor, Mr. Goan is he's a lifelong Madison resident with parents, siblings, and extended family and friends in the area. So he is connected to the community. He's also employed and while we acknowledge that this case comes in addition to some other cases, he was reduced to signature bonds in both of those cases and has not failed to appear at any time. And $5,000 would be prohibitive, so we'd be suggesting a more modest amount of cash, like $500.
All right. I think it's a cash bail case. He's already out on an OWI, allegedly picking up another one and then eluding law enforcement. That's the most concerning part of this case. It's not consistent with somebody who's going to show up in court voluntarily. Apparently has the ability to obtain private counsel. I think 500 would be on the light side to assure appearance in court. I'll set $3,000 cash bail, order that he not operate a motor vehicle at all, and that he not possess or consume any alcohol at all. What about time limits for the preliminary hearing?
I think that we will preserve them for now. Okay.
Where is that file?
No, he said 3,000.
Sweet. So the time limits on that. It's here, it will come 2 weeks.
Yes.
Let's just leave them in time. So
Yeah.
that not really.
Oh, thank you. Yeah.
I'm not going to decide what the time is going to change when it happens to the initial public hearing. So I think we should leave the time limits intact. It's going to be rather quickly if you want to have the other bit of it's going to it's not just say.
Well, unless you want supposed to be.
Just leave them intact.
Okay, yeah, we'll keep time.
Okay, sounds good. We are adjourned.
This way, sir.
What's next? PERCY J KIGHT. Ready?
We'll call the state of Wisconsin versus PERCY KIGHT. It's 26 CF 1536 appearances.
DA Bridget Cook for the state.
PERCY KIGHT appears in person and in custody, represented for today's hearing by Attorney Will Anderson of the Public Defender's Office. It's received a copy of the criminal complaint. We will waive its formal reading. Do you want mail to the Milwaukee Street address? Well, this is a very similar charge. Oh, it's just that's kind of a good mailing address for Mr. KIGHT moving forwards would be 5907 Milwaukee Street, apartment 201 in Madison, 53718. He has applied for a public defender and he is eligible. Thank you.
Great, thank you. I'll make findings of probable cause, get not guilty, please enter to the charges. The public safety assessment recommends a signature bond, state's position on bail.
State is recommending $3,000 cash and no contact with DMN. That's D as in dog, M as in Mary, N as in Nancy. He is currently on 3 different felony bonds, including one that's been set at $500. All of them involve the same 15-year-old victim. One is for sexual assault in Jefferson County, and one is for an assault here in Dane. The state believes that Mr. KIGHT is not willing to comply with bond, or that the victim will be safe without some amount of cash here.
And Attorney Anderson.
Thank you, Commissioner. We would be requesting that the court issue a signature bond in this case. That is what the PSA is recommending. Note that the underlying offense here, other than the bail jumpings, is a Class B misdemeanor for sending text messages. The PSA indicates that Mr. KIGHT has no missed appearances in the past 2 years. So understanding that he may have cash bail posted in another case and maybe facing more serious charges in another case, the $3,000 requested by the state in this case are far beyond his means and seem to be out of proportion for what's been alleged here, what the PSA is recommending based on his appearance history, and frankly, what he could afford. He is indigent and qualifies for a public defender. So I would ask that the court follow the PSA and issue a signature bond. Failing that, I would request no more than $500 cash bail. Thank you.
All right, well, it is very concerning that he's allegedly continuing to have contact with this particular victim, having been ordered on multiple occasions not to have contact with that victim. If this were an Act 3 eligible case, something greater than $3,000 is probably appropriate. It's not, unless the state can convince me otherwise. I don't believe any of the charges meet Act 3 analysis. So I'm simply dealing with a failure to appear analysis. I've got concerns about that when somebody keeps making promises and then allegedly doesn't follow those and they're already out on cash bail. I'm going to set $500 cash bail, order a no contact, direct or indirect with DMN. What about time limits for a preliminary hearing?
In this case, Your Honor, let me just confer with Mr. Kite very quickly.
Sure.
Your next hearing would normally come up in we could set a status topic instead, give you some time to know your appointment and figure out what you want to do with the preliminary hearing. Other than just have it come up in one. I'll figure it out. Wherever we keep it moving. Yes. Okay. Let's keep the time limits intact, please, Commissioner. Thank you.
We are adjourned.
Hammonds is next, JAIDYN Hammonds, forfeiture.
Okay, we'll call the County of Dane versus JAIDYN Hammonds. It's 26 FO 1299 appearances.
Bridget Cook appears for the county. JAIDYN Hammonds appears in person in custody without counsel.
All right, and Mr. Hammonds, the good news is you're not getting charged with a crime, and I don't think anything else is holding you in custody, so I think you're going to get released today no matter what. They've charged you with county disorderly conduct. That's a non-criminal charge. We're not setting bail or anything like that. But it is the type of case where they'll have an offer, and if you want to accept that offer, you can be done with it. If you don't, you're still going to get released, but you'd have to show up for future court dates, okay? What's the county's offer?
The county would resolve the case for court costs.
If you wanted to accept that and enter a no contest or guilty plea, you'd have to pay $114.50 in the next 60 days or work out a payment plan with the clerk's office. Did you want to accept that offer? Or do you want to enter a not guilty plea and contest the charges?
I will accept them.
Okay, I'll accept that as your no contest plea to the charge. Or do you pay $114.50? They're going to give you some info about making the payments and you should get processed and released yet today, okay?
Pay, get out.
No. This isn't like bail. You got to pay that in the next 60 days. If you need more time than that, contact the clerk's office and then you can try to work out a payment plan to extend it beyond the 60 days.
Okay.
But you're getting released no matter what, okay? You're welcome.
Nash is next, Ellen Nash. Dash.
We'll call the state of Wisconsin versus Alvin Nash Jr. It's 26 CM 1612 appearances.
Bridget Cook for the state.
One moment, Your Honor.
Perfect.
Your Honor, Alvin Nash appears in person in custody by student attorney Caroline Scott under the supervision of Attorney Anderson. We have received a copy of the complaint and waive its reading. Is this the right address?
Yeah.
Okay, the address is correct, and Mr. Nash is eligible for public defender services.
Great, I'll make findings of probable cause and are not guilty pleas to the charges, state's position on bail.
State is recommending a signature bond, no operation of a motor vehicle without a valid driver's license, and no operation without a functioning IID.
Any objections?
No objections.
Okay, we'll order a signature bond. The conditions will be that you not operate a motor vehicle unless you have a valid driver's license. And you also not operate a motor vehicle without a functioning ignition airlock device installed. And we are adjourned.
Garrett is next, we're gonna do.
Commissioner, this is Attorney Amanda Reek, and I am here for what I was informed is going to be an initial appearance from Michael Washa as Marcy's law counsel. I have a hearing in Dane County at 2 o'clock, so I'm gonna log on. I'm on my computer right now. I'm gonna switch to my phone so I can walk over there. But if you wouldn't mind just giving me a like maybe 5 minutes to walk over to the courthouse before you call that case so that I have the chance to get to a conference room to log on, if that would be okay.
Yeah, it's a Tuesday afternoon. We got plenty of cases, so we'll be here for a
Okay.
while. I appreciate you letting us know that you were here to make a statement for the victim, so we'll make sure that you have the opportunity to do that.
Thank you so much.
Yep, you're welcome. Washa, so can't do it until she's able to be back.
Okay.
All right, we'll call the state of Wisconsin versus Laurel Garrett, 26 CF 1540, and then a bail hearing in 26 CM 989 appearances.
Bridget Cook for the state.
Laurel Garrett appears in custody via Zoom by student attorney Caroline Scott under the supervision of attorney Anderson. Ms. Garrett, do you have a copy of the criminal complaint?
No, I don't. That's what I gave you, that piece of paper. Oh, sorry, yes, I did it.
Okay, and is the best address for you still the Beacon?
Yes.
Okay. And Ms. Garrett is eligible for public defender services.
Great, we'll make findings of probable cause and are not guilty pleas to the misdemeanors. There's a PSA report. It recommends cash bail. And then we also have to address bail in 26 CM 989. Looks like there was a failure to appear on July 10th. State's position on bail?
Sure. Beginning with 2026 CF 1540, the state is recommending $1,000 cash. The defendant failed to appear on June 29th, 2026, as well as previously on December 3rd, 2025 and July 24th, 2025. Cash was posted on July 10th, and then the missed appearance Your Honor referenced was on July 11th. And the state would also ask for a no use or possession of alcohol condition. The cash request is to ensure appearance. 26 CM 989. As I mentioned, there was a failure to appear on July 10th or July 11th. I'm not sure exactly which one it was. But just last week, after bail was set, and the state is recommending an increase of that bail to $500.
All right, and I'm not sure that she posted cash bail in 26 CM 989. Is there some other case that she maybe posted cash bail in?
I'm not sure. It looks like in maybe a separate case there was cash posted. I'm just seeing a note that cash was posted on July 10th, but I only have the DA case number, so, oh, just kidding.
Yeah,
It's
case-
26 CF 1143.
Yeah, I just found it at the same time. All right, defense position on bail?
Yes, Your Honor. Well, we understand that Ms. Garrett has a spotty appearance history. We would remind the court that she is homeless, and it appears that is possibly suffering from some mental health struggles based on the facts alleged in the complaint today. In addition, she informed our intake staff today that she was ill when she missed court most recently, and previously has sat for a long period of time on $100 cash. So we would be requesting a much more modest cash amount. The 200 that was posted on her behalf by a community organization and not by Ms. Garrett herself. So any high amount of cash, and specifically the amount that the state's looking for, would be completely prohibitive for Ms. Garrett.
All right, the appearance history suggests that there's a need for cash. The felony case is an Act 3 eligible offense. I'm gonna set $750 cash bail there, order that you not possess or consume any alcohol. In the misdemeanor case, I'll set $250 cash bail with the prior conditions. Should we schedule this for a timely preliminary hearing?
Yes, please, Your Honor.
Okay, we are adjourned.
Schreckenthaler is next, Devin. Or Kelton.
Right, we will call the state of Wisconsin versus Devin Schreckenthaler. It's 26 CM 1617 on bail hearings in 25 CM 1746, 25 CM 784, 23 CT 289, and 22 CM 1393. Appearances?
DDA Bridget Cook for the state.
Devin Schreckenthaler appears in person and in custody, represented for today's hearing by Attorney Will Anderson of the Public Defender's Office. He has received a copy of the most recent criminal complaint, would waive its formal reading, ask the court to enter not guilty, please. Just one moment. Okay. Okay, do you want that on all the cases then?
Yes.
Okay, the address on the most recent criminal complaint, 1642 Drotning Road, DROTNING Road in Stoughton, 53589 is the good mailing address for Mr. Schreckenthaler moving forwards. And if that could be added to all of the cases, that would be appreciated. I have a note here that he did apply for a public defender and he is currently not eligible to have one appointed in this matter. Thank you.
All right, so Mr. Schreckenthaler, the deputy's giving you the public defender info. You can always reapply with them. You can hire an attorney on your own if you're able. If you can't, and you're kind of in the middle, you could apply for a county attorney. I'll make a finding of probable cause in the new case, enter not guilty, please. So there is a failure to appear, I guess, on various dates, it looks like in the misdemeanor cases. At least one where he's posted cash bail and at least one with a signature bond. So we'll need to address bail in those cases as well. What's the state's position on bail?
In the new case 26 CM 1617, the state is recommending $750. As Your Honor mentioned, he has a history of failing to appear. I'm seeing one in 2022 where then he posted $500, then failed to appear in 2023, then posted a total of $750. August 2025, there was a warrant pending at the time of an arrest on that one. And then most recently, September 15th, 2025, and a warrant was pending at the time of that arrest as well. Seems like he's only willing to come to court when arrested on new charges. State would also recommend a no consumption or possession of alcohol on this case. And then in each of the previous cases, the state would be asking for an increase of $500 in the cash and the standard non-monetary conditions.
Wait, and Attorney Anderson?
May I just have one moment to speak to Mr. Schreckenthaler? Off the
Sure.
record?
I apologize, Your Honor. I said standard non-monetary conditions on those other cases, but I meant reinstatement of the previous
understood.
conditions. Thank you.
Appreciate the clarification. Working with him, my source income, so. On my cash.
Thank you, Commissioner. I think the $750 suggested by the state in the newest case is makes sense given some of the appearance history. And I would ask that the court, excuse me, impose that amount in the new case, but then reinstate the cash bail and signature bonds in the older cases. Otherwise, I think the amount of bail would, if I'm doing the math correctly, total bail for release for Mr. Schreckenthaler would be over $2,000. I do believe that is beyond his means. When he spoke, he's been working recently for his uncle, but is lacks significant funds to post that amount of bail, and so would remain in custody in the Dane County Jail, would likely lose that source of income. I think that $750 would be a significant amount of money for him to post. He does have some cash posted in the other cases that was not forfeited. So I think reinstating that amount would make sense as well. And that's what I would ask. Thank you, Your Honor.
All right, and I don't think any of the cash bail has been forfeited, but the clerk can correct me if I'm wrong. So that's actually still on file and nobody's requested that I forfeited here today. There's a clear need for cash. He's posted, in excess of $1,200, failed to appear and been on warrants for a long time in these cases. I certainly think that the $750 is reasonable in the new case. I'll order that and order that he not possess or consume any alcohol. I just wanted to take a quick look at the other cases before I determine the bail there. I think a $750 cash bail in each of those cases is warranted and necessary. Obviously, he's got the cash already on file that applies to those bails. The prior non-monetary conditions will remain and will be adjourned.
Yeah.
Who is next? Diana, let's see, it's gonna be.
It'll be a total of $1,750 new bail to get out.
It's supposed to.
Well, I already subtracted what was posted to get you to the $7.
I need to clarify what the numbers are that.
Did you want to come up to the door?
No, 750 per case in each of the cases. He's got 500 in two of the misdemeanors that applies to that bail and 250 in one of them that applies to that bail. And then, so it's 750 cash bail in each of the cases. Any of the bail that's on file has not been forfeited and is still applicable to the bond.
Thank you, that's what I.
Yeah.
We can work on the bill. Yeah.
All right, and I think we have Attorney Reek back if we need to do washout.
Okay, we can watch that.
Who is this?
Over. You and Moon, we're gonna do Moon quick. The girl, no, honestly.
Great, we'll call the state of Wisconsin versus Diana Moon. It's 26 CF 888 appearances.
ADA Bridget Cook for the state.
Diana Moon appears in custody via Zoom by student attorney Caroline Scott under the supervision of attorney Anderson. Ms. Moon, do you have a copy of the complaint?
No, I don't have a copy of anything. They told me that they didn't have a
sorry.
link to give me.
I'm so sorry. That's my fault. This is a bail hearing, not a, yep.
Yep, but maybe if we could confirm, we've got 2009 Northport Drive, apartment 21 in Madison as a mailing address. Is that still a good place for mail?
Yes, sir. And I just wanted to ask if I'll be able to speak on my behalf today.
So you can speak with the public defender if you want to, but where should we send mail?
Yes, 2009 is still a good address.
Okay, and so we're here because Ms. Moon didn't appear on July 9th. Actually, it says defendant was present but left before case was called, warrant
No,
issued.
see, I told you that court.
Okay, so Ms. Moon, please don't interrupt. You'll get a chance to speak or have your lawyer speak. So I assume that I'm not sure that she ever had an attorney before. Do we know if she's going to be eligible for? an
She
attorney?
is eligible for public defender services, yes.
Okay. Very good.
Yeah, she did.
Okay. All right. And I don't know if you want to speak with Ms. Moon about the failure to appear first, or whether you want to hear the state's thoughts, or they'd rather hear what she has to say before they make any recommendations. I'm willing to do either option.
Okay with either. Planning on it's 2:50.
Okay.
We'll go have a.
Can we talk to her quickly? Yeah.
Let's just have that.
Great, we're back on the record in the state of Wisconsin versus Diana Moon. Appearances as before, and Ms. Scott, any information you want to provide about the failure to appear?
Yes, Your Honor. Ms. Moon let us know that she, and this is also reflected on CCAP, that she was at court that day. And it seems like there was some kind of a miscommunication that happened. She had already in June attended a status conference, but it had been rescheduled because she didn't have counsel. And then when she came back for this status conference, she again didn't have counsel and was told by court staff that she would leave, and that could leave and it would be rescheduled. So I think it appears that she left under the impression that they were just going to set her out for a new court date, and somewhere along the line there was a miscommunication because she was clearly at court that day.
Okay.
Yeah, so.
And what's the state's position on bail?
Suit is recommending $250. I understand the representation from defense on why she missed court that day, but still she appeared and then decided to leave. And I think some cash is required to ensure that she comes to court in the future.
Right. I'm looking at the PSA. It looks like she has absolutely no prior criminal record, never missed court. She showed up. What she asserts is hard to believe that somebody would have told her, well, you don't have to be here for your court date. But perhaps there was some confusion on Ms. Moon's part. I'm willing to give her the benefit of the doubt. She was found in relative short order here, so. We'll reinstate the signature bond. Ms. Moon, just so you know, you gotta appear for court dates, and usually you can't just leave and they get rescheduled. We will set it for another status conference, I assume.
Thank you, somebody.
Yep, you're welcome. We are adjourned.
Washout next. Michael. Washout.
All right, we will call the state of Wisconsin versus Michael Washa. It's 26 CF 1537 appearances.
Bridget Cook for the state.
And Michael Washaw appears in person and in custody, represented for today's hearing by Attorney Will Anderson of the Public Defender's Office. He's received a copy of the criminal complaint, and we would waive its formal reading, ask the court to enter not guilty pleas to the misdemeanor charges. The address printed on the criminal complaint is still a good mailing address for Mr. Washa. And I have a note here that he did apply for and has been deemed eligible for a public defender in this case. Thank you.
Right, I'll make findings of probable cause and are not guilty pleas to any misdemeanor charges. There's a public safety assessment that recommends cash bail. And then I believe Attorney Reek is here under Marcy's law on behalf of the victim. So I'll turn it over to you, Attorney Reek. And you're on mute.
Yes, sorry, Judge, it's kind of hard to see which commissioner is assigned. Could you just remind me who the court is today?
Oh, it's Court Commissioner Asmus. And you're again on mute.
Thank you, Commissioner. I am appearing today on behalf of the victim in this case. I could not file my notice of retainer under Marcy's law because as of checking up until a few minutes ago, there wasn't a complaint, so I didn't have the complaint number. So my apologies for that, and thank you for allowing me to appear. As it relates to cash bond, we are asking for a cash bond to be set in the amount of $50,000. I have reviewed a copy of the Public Safety Assessment Report, Document 3 in this case. As the other parties have and are aware, the recommendation is for cash bail. In this particular case, I've received a copy of the complaint and I have reviewed it. I'm surprised by the charging decision, or I should say, the lack of some of the charges that I sort of anticipated would be considered. Of course, we don't have all of the reports yet, but my understanding is that Mr. Washa went to this residence repeatedly looking for an individual that he did not find. Wednesday, June 24th, my understanding is not the first time that Mr. Washa went to this residence. When he did, it's my understanding that he had a weapon with him. I don't see that there are weapon enhancers charged at this time, but that's a conversation we can have down the road. The reason that I bring that up is because Mr. Washa is currently on bond in a Dane County case, and that would be Dane County case 26CM642, where he is charged with disorderly conduct with use of a dangerous weapon in that particular case. Again, I am not certain why the charging decision was made as it is, but in reviewing the criminal complaint, it appears that a dangerous weapon is alleged to have been used in that case. And one of his bond conditions is that he was not supposed to have a dangerous weapon. And in this particular case, my understanding is that he had a mallet that he used to assault the victim. I've also reviewed Dane County case number 08 CM, and I apologize, this was before e-filing, and the complaint that I pulled does not have the remainder of the case number on there. That case was not listed on CCAP, so I can only assume that perhaps at some point in time there was a deferred agreement offered or expungement offered. But in that case, again, Mr. Washa was only charged with disorderly conduct, despite the fact that that complaint asserts from the other individual, the victim in that case, that Mr. Washa was punched him in the face 5 or 6 times with a closed fist, and that there was also some damage that occurred to property in that case. And then perhaps most concerningly, in case number 05CF470, Mr. Washa has some incredibly serious charges that he was charged with, 2 of which were dismissed on the prosecutor's motion. First-degree sexual assault by use of a dangerous weapon as a Class B felony, kidnapping, seizing, or confining without consent as a Class C felony, operating without consent by possessing a dangerous weapon as a Class C felony, of which he was convicted of, and armed robbery with threat of force as a Class C felony, which he was also convicted of. In that particular case, based on the conviction, it's my belief that at the time, perhaps the agreement that was reached was reflective of his age, because he was born in 1987. So at that time, it's my understanding that he had either just graduated high school or was close to doing so, but nonetheless, for a plea to the Class C felony, possession of a dangerous weapon, He was given 10 years of probation, and on count 4, despite this being the first public record I could find of a conviction for him, he was sent to prison for 1.5 years and placed on extended supervision for 8.5 years. I requested a copy of that criminal complaint, but I don't have it yet because given the date of the case, it is stored off-site. And so it's going to take a little bit for the clerk's office to obtain and get that to me. I don't know if the court is able to view that or if the state would be able to recite any of the details from that case since it was a Dane County case. But given objectively just the charges themselves, they're incredibly serious, if not very close to the charges that he's facing right now. It is clear that Mr. WASHA has a history of insanely violent charges that he was convicted of even as of 20 years ago. He has been convicted of different cases, including cases where he is alleged to have assault individuals during the time that he would have been on supervision, both probation and extended supervision. He is currently on bond with a condition that he's not supposed to have a dangerous weapon, and yet we are here for charges related to him using a dangerous weapon. My understanding from reading the complaint and speaking with my clients is that he had absolutely no reason to be at this residence. He had absolutely no reason to engage in the behavior that he engaged in. It's incredibly concerning behavior that he engaged in not only at this house, but then subsequent to leaving that residence. It's my understanding also had encounters with several of the neighbors. In speaking with the district attorney's office and my clients, it sounds like they are asking for specific conditions that we believe are relevant and we hope that the court will impose. So I don't need to go through those because I trust that the information I have from their office as to the conditions they're asking for will be recited by them. But for someone who has a history of violent behavior and similar charges dating back over 2 decades now, we believe that a significant cash bond is appropriate in order to comply with all of the portions of Act 3 that the court is to consider in setting bond. We especially agree with the condition as asked for or indicated on the public safety assessment that he be supervised pre-trial, that he have to comply with electronic monitoring to ensure the safety of the victims in this case. But we are asking that he be held on a significant cash bond.
All right, thank you, Attorney Reek, and I should let you know, Judge Kondar popped me up and she still needs you for a hearing, so I'll leave it to you as to whether you want to listen in or you want to go to that hearing.
Thank you.
Yep. All right, let's hear from the state. What's your position on bail?
State is recommending $10,000 cash. I'm not going to repeat everything Attorney Reek said about the seriousness of what's alleged here. The conditions the state is recommending are no contact with Terry B. or his family, Daniel C., Jonathan P., or Nancy P., and no possession of any incendiary material. As far as a geographic ban, the state is recommending the area bordered by East Buckeye, Tarragon Drive, and Starker Ave, and Woodvale Drive. I don't have a map prepared, but we can work on getting one for that area.
I'm sorry, what was the last street name that you said? It is a little bit.
Yeah, sorry, no worries. Woodvale Drive was the last one. I can repeat all of those if you'd like.
All right, and was that the extent of the conditions?
Yes.
All right, and any argument you want to make in regards to the cash bail?
I think Attorney Reed covered it. It's a serious situation that's alleged here. And he was on bail and violating it at the time that this occurred.
Great. And Attorney Anderson.
Thank you, Commissioner. So looking at the public safety assessment, I would note that while it does recommend cash bail, that seems to be pursuant to the decision-making framework step 2, which as I understand is related to the allegations here. And looking at the specific risk factors in the PSA, it notes that there are no prior failures to appear in the last 2 years or ever, despite some of the cases that we've heard about here on the record today, resulting in at least the one violent conviction and a prior sentence to incarceration. So Mr. Washa evidently does appear for court. I'd say he also evidently follows the rules of supervision because as far as I can tell from reviewing CCAP, he successfully completed that 8.5 years of extended supervision without being revoked at any point and then discharged. So what we're talking about setting cash bail in this case, what we're talking about is an Act 3 analysis, I believe. Obviously, some of the offenses here are Act 3 eligible. The primary purpose of Act 3 then is to set bail at an amount necessary to protect the public. I think a key fact that's missing from the analysis here is that after Mr. Washa was taken into custody on June 24th, he was taken to Winnebago Mental Health Hospital for a 72-hour evaluation. He was ultimately committed to Winnebago and has since signed a consent decree to take medication. I believe the medication is Halidol, which I believe is used to treat a psychosis. So when it comes to the protection of the public moving forwards, it would appear that what was going on with Mr. Washa a little under a month ago was the result of a mental health crisis, that the government's first option was to intervene to stabilize Mr. Washa's mental health, and that they have done so by applying medication and having him agree to take that medication or be recommitted to the mental institution for, I believe, the next 6 months is how long that commitment is in place for. And then, of course, there'll be possibility to renew the commitment as it's coming close to its termination. So for those reasons, I think that the Act 3 factors are significantly diminished from where they would have been on June 24th, 25th, 26th, because he is taking that medication. I would ask that the court consider a signature bond in this case. Mr. Washa is indigent. He qualifies for a public defender. His only income right now is unemployment, as he was recently terminated from his job at an auto parts retailer. So a large amount of cash bail would be beyond his means. And as he's been coming to court, as he is now under that commitment, as his criminal history is quite dated, and evidently he complied with supervision for a number of years without issue, it seems like the primary cause of this behavior, if the allegations are true, any of them, was a mental health episode that has since been dealt with through a different part of the statutes. And because of that, he would be an appropriate candidate for a signature bond or lower cash bail than the $10,000 requested by the state. Thank you, Your Honor.
All right. And any response from the state?
No, Your Honor.
All right. And I do want to just clarify one point with Ms. Anderson. I believe a 5-3 on new criminal activity and failure to appear either way results in some form of a cash bail recommendation under the tool. The nature of the charges may have enhanced the level of the cash bail recommendation, but Ms. Anderson, can you speak to that?
Yes, you are correct.
All right, thank you. And Attorney Reich, I don't know if you're back, and if you wanted to respond to anything briefly, you can go ahead.
Thank you. I understand and appreciate that argument that the court is making, but I think that if perhaps there was not such a history of extended behavior, I did have to step away for just a moment, but I didn't hear any recitation that I'm not trying to diminish the recitations regarding his arrest and recent mental health treatment. Quite frankly, I'm glad to hear that, but there hasn't been any sort of recitation that sort of situation, if you will, were true back in 2005 when he was charged, back in 2008 when he was charged, or this March when he was charged, all with cases involving assault to other individuals and all involving incredibly serious conduct several of which involve use of a dangerous weapon. So that may be something that is recent or new development for him. And I can very much appreciate that, but that wouldn't explain what was allegedly going on dating back 20 years for this individual.
All right, thank you. It's an incredibly concerning set of facts. Allegedly has no real relationship with this person, shouldn't have been there, barges in, physically assaults the person, dispenses gasoline, and is threatening to kill this particular person. I can't imagine how terrified they must have been in their position. I have to look at the Act 3 factors. One is failure to appear risk. That's a mixed bag. He's never missed court. That's certainly in his favor, and he's had serious charges in the past. These are also very serious charges, and the type that, if convicted, may well result in a lengthy prison sentence, and that provides some incentive not to appear. I have to look at any affirmative defenses. You know, he may be pleading NGI at some point, or alleging that he didn't do this. I don't know. I don't have a lot of information to determine whether this is a case that would be an NGI type of case. There's no question there's mental health issues. He's apparently committed and found to have a mental disorder, and found to be dangerous, and that's why he was committed. The prior history of violence is concerning. While some of those are very dated, they were very significant charges, very concerning. He was also out on bail in an Act 3 offense, as Attorney Reed notes, with a disorderly conduct while armed. I think had he not been committed, not been treated, and doctors saying, I mean, he's treated to the point where they think he's not an immediate danger to the public, the $50,000 that Attorney Reek asked for certainly would be warranted. I do think it is important to take into account that he is being monitored by the mental health system. He violates any of those particular conditions, he can be immediately reconfined and have a reconfinement hearing. I still think that there's a need for a significant cash bail. I think the state's recommendation is just about right on the nose, taking into account that he is being monitored by the mental health system, is required to take medication. Doctors has obviously come to a conclusion that he is not an immediate and present danger that he was previously. So I'm going to adopt the state's recommendation. I do think pretrial services is probably appropriate. I generally don't do that when somebody's going to be on a waiting list. Given what's alleged here, I think having some additional backup is appropriate. That said, I don't think I have the authority to say he can't be released if he posts the cash bail because pretrial services can't take him. So if the cash bail is posted, he needs to report to pretrial services, and then they'll let him know when he can be brought into the program and equipped with the GPS, and he needs to then report and follow all their rules that they provide for him. I will order the address ban, and I won't restate that because I couldn't write down all the addresses quickly enough, but that's certainly an appropriate condition. I'll order the no contact director and director of the following individuals: Terry B, Daniel C, Jonathan P, and Nancy P. Did I get all that right?
Terry B as in boy, Daniel C as in cat, and then the last two are P as in Peter.
Okay.
I think there's also a request for any family member of Terry B.
Correct.
All right, and I'll order a no contact director and direct with any family member of Terry B. I'll order that you not use or possess any incendiary devices. I'm going to order that you not use or possess any dangerous weapons, as that term is defined by the Wisconsin state statutes. And I'm going to order as a condition here that you comply with your chapter 51 requirement, all the rules with that release as well. What about time limits for a preliminary hearing?
We'll leave those intact, please, Commissioner.
Okay, we will get that scheduled and we'll be adjourned. Thank you, everyone.
The next hearing will be this $10,000.
Stay here, right there.
Yeah, I'm sure as well. Okay, Mr. Washington. Yes, sir. All right.
Commissioner, could you please remind me if the court is setting the actual literal date for the prelim right now?
The clerk would have picked a date. Do you have that still handy? Otherwise, it should be on CCAP.
I do have the date, it will be on CPAC at this moment, it's next Tuesday at 1:30.
I am in a jury trial that day in Dodge County. Would it be possible for me to either appear remotely or for a different day to be chosen?
Why don't you make a written request to appear by phone or something, and that'll be up to the
Perfect.
judicial official. I don't want to commit it somebody else and their calendar to something that they don't want.
That's fine. Thank you so
I
much.
know it's always difficult to do a hybrid hearing with people in person, and Zoom phone's probably better.
Okay, thank you.
Yep. All right, this is Mr. Freeman. All right, we will call the state of Wisconsin versus Xavier Freeman. It's 26 CF 1534 and 26 CF 1539 appearances.
Muy bien, estamos aquí en el estado de Wisconsin contra Javier Freeman, 26 CF 1539, 26 CF 1534.
ADA Bridget Cook for the state.
Fiscal asistente Bridget Cook por el estado.
Defendant Xavier Freeman appears in person and in custody.
El acusado Javier Freeman, preso aquí.
Represented for today's hearing by Attorney Will Anderson of the Public Defender's Office.
Representado hoy día por el abogado del defensor público Will Anderson.
He's received copies of both criminal complaints and would waive their formal reading.
Él ha recibido copias de las dos denuncias y renuncia que se lee.
Would ask the court to enter not guilty pleas to all misdemeanors.
Pedimos que se entre en el acta una declaración no culpable a los delitos menores.
Okay. If Mr. Freeman's mailing address could be changed to 116 Park Circle, Sun Prairie, Wisconsin, 53590.
Si la dirección del señor Freeman se puede modificar a 116 Park Circle en Sun Prairie, 53590.
And I have a note that he has applied for and been deemed eligible for a public defender in both of these cases. Thank you.
Y tengo indicado que él ha solicitado y ha calificado para un defensor público en cada uno de los casos.
All right, although we have certified Spanish interpreter Fred Svensson interpreting.
Puedo notar también que tenemos al intérprete certificado Fred Svensson interpretando.
And I'll swear Mr. Svensson in. Do you swear or affirm that you will truly, accurately, completely, and impartially interpret our proceedings at the jail here?
Y en serio, y el intérprete acaba de prestar juramento que va a interpretar bien y correcto.
All right, we'll make findings of probable cause for the charges and enter not guilty, please.
Vamos a hacer una determinación de motivo fundado y entrar una declaración no culpable en el acta.
What is the state's position on bail?
¿Qué es la posición del Estado sobre la fianza?
State is recommending on 26 CF 1534.
En el caso 26 CF 1534, el Estado recomienda
$5,000 cash and no contact with Aisha O.M.
y una fianza de $5,000 sin ningún contacto con Aisha o M.
That's spelled A-I-S-H-A.
Eso se deletrea A-I-S-H-A.
The support for the cash request is defendant continues to violate court orders in older cases.
La solicitud o nuestra solicitud para una fianza de caución es basada en que se sigue cometiendo sigue siendo acusado de crímenes con casos pendientes.
including no contact orders and after posting cash.
y con condiciones previas de no tener contacto y aún después de pagar una fianza de caución.
In 26 CF 1539,
En el caso 26 CF 1539,
state is recommending $20,000 cash bail
el Estado recomienda una fianza de $20,000 de efectivo
and no contact with Aisha O.M.
y ningún contacto con Aisha O.M.
This would be Mr. Freeman's fourth open case with the same victim,
Este sería el cuarto caso pendiente para la misma víctima
and his violence is escalating as well as his prison exposure.
y su violencia se está aumentando tanto como su exposura de tiempo de cárcel.
Under Act 3, the state believes that high cash is necessary to protect the victim and ensure court appearances.
Basado en la información, el Estado opina que una fianza de caución de un valor alto es necesario para proteger al público y a la víctima.
Great. And Attorney Anderson?
Y abogado Anderson.
Thank you, Your Honor.
Gracias, su señoría.
We'd be asking that you impose a considerably less bail in these, cash bail in these cases than what the state has requested.
Estamos pidiendo que se imponga una fianza de caución de un valor mucho más bajo que la de la recomendación del Estado.
In the first case, I'm sorry, I don't have the actual CCAP numbers in front of me. So in the case that the state discussed first, where they requested $5,000 cash bail, we would ask for $2,000 in that case, please.
En el primer caso, no tengo los números de casos delante de mí, pero en el primer caso que el Estado mencionó cuando recomendaron una fianza de $5,000, estaríamos recomendando $2,000 de fianza.
And in the other case, would request no more than $5,000 cash. That would bring the total of unpaid cash bail to $7,000 for Mr. Freeman.
Y en el otro caso, recomendaríamos una fianza de $5,000, que resultaría en un pago de fianza de $7,000 para el señor Freeman.
That would be a very significant amount of money for Mr. Freeman to post. He has not worked in over a month and is currently receiving only unemployment for his income.
Eso sería una cantidad significativa para el señor Freeman, quien solamente está recibiendo pagos de desempleo, como no ha estado trabajando en el último mes.
He is eligible for a public defender, so he also does not have any valuable assets that he could sell or pawn to post bail.
Él también se califica para un defensor público, así que no tiene muchas pertenencias o propiedades que pudiera vender o poner en la casa de desempeños.
So it may well be that even $7,000 in cash bail would have the effect of keeping Mr. Freeman incarcerated in the Dane County Jail, but certainly $25,000 would have that effect.
Sería posible que él se permanezca encarcelado con esta fianza, pero con seguridad estaría aquí preso durante la pendencia de sus casos si tendría que pagar la cantidad más alta.
I don't have any information about court appearances for Mr. Freeman, so as far as I can tell, this is solely an Act 3 determination.
No tengo indicado que él ha faltado a la corte anteriormente, entonces esto necesita ser una determinación solamente bajo la ley número 3.
Beyond that, I'm struck by the offense dates in these two cases, and that the more serious case with alleged violent acts occurred almost a full month before the second case, in which all that's alleged is a no contact violation.
Bueno, algo que me salió es que el primer caso era el caso más grave y después resultó el otro caso que es un caso solamente quebrantando condiciones de no tener contacto. Así que me sorprende la diferencia entre las fianzas.
To me, that seems to suggest that while some cash bail may be necessary to protect the public here, the large amount requested by the state is not necessary. And I would ask that the court consider an amount potentially within the means of Mr. Freeman and his family, like $7,000. Thank you.
Y bueno, eso sugiere que no es necesario una fianza bien alta para asegurar que se presente a la corte, pero la cantidad muy larga no es, I'm sorry, the large amount
requested by the state.
No es necesaria la gran cantidad solicitada por el Estado. Una cantidad de $7,000 es algo que la familia pudiera alcanzar a pagar.
All right. Well, I appreciate the credibility of the argument asking for cash bail, because this is clearly a cash bail case.
Bueno, aprecio el argumento de que se está de acuerdo que esto debe ser un caso de una fianza de caución, porque esto obviamente es un caso donde sí merece tener una fianza de caución.
Mr. Freeman has shown that simple court orders and promises and posting cash bail are not sufficient to protect the victim in these cases.
El señor Freeman sí nos ha demostrado aquí en la corte que una fianza de promesa no es suficiente para proteger a la víctima. I'm sorry, Your Honor. Could you instruct them not to speak when I'm interpreting? It's just really distracting and
Yes,
interrupts
you
the
could,
process.
wait until the
Si
interpreter.
pueden esperar a la interpretación antes de seguir hablando, por favor. So the previous thing was Mr. Freeman.
Well, I think he's shown that simple orders and promises and cash bail are insufficient to protect this victim.
El señor Freeman ha demostrado que órdenes y promesas no son suficientes para proteger a esta víctima.
He's shown an ability to post cash bail. It looks like I set $2,000 cash bail in an underlying case that's very similar to the 26 CF 1534 case.
Él ha demostrado una habilidad para pagar una fianza, como pagó una fianza de $2,000 en un caso subyacente con hechos similares al caso 26 CF 1534.
It looks like he's been able to post $750 and $1,000 in other cases very recently.
Y parece que él muy recientemente ha podido pagar $750 y $1,000 en diferentes casos.
So there's a clear need to increase the cash bail to have on the line to be forfeited.
Entonces parece que hay una gran necesidad de tener una fianza de caución que se pudiera perder si no se presente o cumple.
I don't see $2,000 as sufficient in 26 CF 1534, since that's what he got very recently for a similar case.
No creo que es suficiente una cantidad de $2,000 en el caso 26 CF 1534, como esa es la cantidad que se decidió en un caso bien similar anterior.
I'll set $3,500 cash bail there and order a no contact direct or indirect with Aisha OM.
Voy a colocar una fianza de $3,500 con la prohibición de tener contacto con Aisha OM, directo o indirecto.
Obviously, 26 CF 1539 has multiple Act 3 eligible offenses and is much more serious.
El caso 26 F 1539 tiene varios cargos bajo la ley número 3, acta número 3, y por eso es un caso mucho más grave.
And warrants a much more significant cash bail.
Y merece una fianza de un valor mucho más alto.
I'll set $7,500 cash bail in order that you have no contact, direct or indirect, with Aisha OM.
Voy a determinar una fianza de $7,500 con la condición de no tener contacto directo o indirecto con Aisha OM.
It looks like Mr. Freeman maybe hasn't been the one who's posted the cash bail, so if the person who's posted in the past is listening.
Parece que el señor Freeman no es la persona quien lo ha pagado en el pasado. Si la persona que lo está pagando está escuchando, por si acaso.
They should be aware that all of that cash bail could be forfeited for Mr. Freeman picking up any new cases or violations of his bond, even if he makes all his court dates.
Y esa persona debe estar enterada de que se pudiera perder esa cantidad de dinero en efectivo pagado de fianza si el señor Freeman infringe las condiciones de su fianza o cometa alguna violación de las condiciones más allá de simplemente no presentarse por la corte.
It doesn't appear as though the state has moved to forfeit the bail that's on file just yet, though.
Parece que el Estado todavía no ha presentado un pedimento para perder la fianza pagada anteriormente.
What about time limits for the preliminary hearing?
¿Qué tal el límite de tiempo para la audiencia preliminar?
If we could leave those intact, please, Commissioner.
Si los podemos dejar en lugar, señor comisionado.
Okay, we will do that and we will be adjourned.
Muy bien, vamos a hacer eso y estaremos concluidos. Shelwa García. Not one.
All right, we'll call the state of Wisconsin versus Mauricio Shalwa Garcia, 26 CF 1538 to appearances.
88 Bridget Cook for the state.
Mauricio Shalha Garcia appears in person in custody by student attorney Scott under the supervision of attorney Anderson. We have received a copy of the complaint and waive its reading. Is this address correct? The address is correct. And Mr. Garcia is not eligible for public defender services.
All right, Mr. Shalwa Garcia, the bailiff is handing you the public defender info. And if you can't hire an attorney on your own after today, you can always reapply with them. Or they can kind of point you in the right direction to apply for a county attorney, which is kind of the middle option. I should note we have certified Spanish interpreter Fred Svensson interpreting, who's already been sworn for our hearings this afternoon. I'll make a finding of probable cause. There's a public safety assessment. It recommends a signature bond, state's position on bail.
State is recommending a signature bond with the condition that he not operate a motor vehicle at all. Mr. Halwa Garcia stated that he turned off the lights and fled from law enforcement and admitted that he had no driver's license. The state believes this is sufficient to support a no operation condition.
All right, any objection?
No objection.
All right, well, what's alleged is very concerning behavior. It's dangerous for you and others. It usually is not something I think is consistent with somebody who's going to show up in court. I've got a joint recommendation. I'm supposed to give deference to that. There's also a public safety assessment that recommends a signature bond. That said, if the state had made a recommendation for cash, that might have been persuasive. The fleeing a scene because you didn't have a driver's license made a mountain out of a molehill. Driving without a license might have been simply a ticket. Now you've got yourself charged with a felony. You don't want to violate the conditions of bail and go driving or miss your court dates, given the nature of this charge, because there might be cash bail that's ordered in the future if you do that. So I'll reluctantly go along with the signature bond, order that you absolutely not operate a motor vehicle at all. What about time limits for the preliminary hearing?
And you have 20 days to have a preliminary hearing, but if you waive time, you can have more time to get an attorney. Do you want to waive the time limits, or do you want to have that hearing within 20 days?
Hearing.
You want it in 20 days? Keep them. Okay, we'll keep the time limits.
Okay, so we will not flag the case for an interpreter in the future. You're not gonna have a lot of time to get a lawyer. Make sure you do whatever you need to do to get one before the next court date. Right? We are adjourned.
On this like that. Hold on. Yeah.
Would you mind if I was ready? What? You mind just real quickly tell me if you're on some kind of later. Yeah, no, really cool. I'm gonna try and look it up to that, so I'm una de la oficina de defensa.
She's working on this, pues lo llevo bajo mi supervisión. Es lo que she has la necesidad de hacer el caso, sí, está preparada a hacer los argumentos para usted.
Yeah, yeah.
Yeah, that's fine.
Okay. Essence.
All right, we'll call the state of Wisconsin versus Pablo Onan Gamaliel, 26 CM 1615 appearances.
ADA Bridget Cook for the state.
Mr. Pablo Gamaliel appears in person in custody by student attorney Caroline Scott under the supervision of attorney Anderson. We have received a copy of the complaint and waive its reading. And is that the correct?
Son correctas para usted en South Carolina. No les hemos quedado.
Okay, what would be the best?
2324.
Drayton Street. Drayton Street.
Drayton Street.
Yeah.
¿Cómo se escribe?
D. Tiene un símbolo, pero.
No te lo puedo dar, pero no lo puedes decir.
D. R. A. I. Y. De falta. Right, T. O. L.
R o sin L.
No trae así.
Drayton Street. Drayton Street. Yeah.
Eso Carolina igual.
And
Solo cambia la.
Newberry, South Carolina.
Yeah.
In Newberry, South Carolina. Apartamento.
Sí, es el 2324.
2324 Drayton Street. Newberry, South Carolina. Mismo código. Yes, same code.
Okay.
And I don't have information about whether he's eligible for public defender services.
All right, sir, the deputy's handing you the public defender info. You can't hire an attorney on your own. Make sure you give them a call to see if you're eligible for a lawyer. And we have certified Spanish interpreter Fred Svensson, who is sworn for our hearings at the jail this afternoon. I'll make findings of probable cause and are not guilty pleas, state's position on bail.
State is recommending $500 cash. The out-of-state address, as well as his behavior here, giving a false name, driving the wrong way, and not being very cooperative with officers, suggests a risk that he will not appear for future court appearances. As far as conditions, the state would recommend no use or possession of alcohol and no operation of a motor vehicle without a valid driver's license.
Can you interpret like my conversations? Is that okay? No, that's no, that's good.
Hay algún dinero que usted puede pagar.
Sí. No sé cuánto será.
A lo mejor no yo vi. Está dando ella. Ellos están pidiendo $500. ¿Tiene usted $500 a pagar para salir? Porque sí, me recomendaría usted otra familia.
Tengo los $500, lo que tendría que llamar, ¿cómo se me también?
I would just have to follow.
Okay. Your Honor, we would be requesting a signature bond here. The charges on the complaint are 2 misdemeanors, and it seems like there was a language barrier when he was dealing with the police, which may explain some of the issues in communication. In addition, this is his only offense in the state. He has no prior criminal history, and for those reasons, we request a signature bond.
I'm concerned about his appearance. Obviously, doesn't really have any ties here. He lives a long ways away. The behavior that's alleged in the charges isn't consistent with somebody showing up for court. I get there can be a language barrier, but I'm not sure why that resulted in him using the name Wilmar, if he wasn't trying to deceive law enforcement. I'm gonna set $350 cash bail, order that he not possess or consume any alcohol, and that he not operate a motor vehicle without a valid driver's license. And we'll be adjourned.
Aries Vega is next.
This is the last one for. Okay, thank you. Yeah.
All right, and this has to be consecutive.
Does Freeman's missing paperwork? You have a bunch of paperwork?
I printed everything. Just I requested everything be printed.
He's missing paperwork?
Yeah, I just saw the body stuff.
I'll check with Victoria while we're doing this.
Okay.
I don't think it's on your guys' end.
Oh, yeah.
I just read I present.
If you went into the signing booth, then maybe, but absent that, I don't think you could have.
Yeah, it's been, race gone. We're gonna inquire, I think this is one where I need.
You have to do consecutive.
Hola. Yo soy una estudiante para estudiante. Para just in this airline.
Oh, yeah.
There's a spouse there, documentar su caso el día. Y luego que la supervisión de la abogada Anderson. Está bien si yo hago su caso el día. Yes, question.
Yes.
Somebody is on Zoom. So it has to be consecutive. Let me know when you're ready. All set?
Yes.
Right, we will call the state of Wisconsin versus Alison Arias Vega,
Este es el caso del estado de Wisconsin contra Alison Arias Vega,
26 CM 1607.
26 CM 1607.
Appearances,
Comparecencias.
The Bridget Cook for the state.
Estado.
Alison Arias Vega appears by student attorney Caroline Scott under the supervision of attorney Anderson. We have received,
Vega comparece por.
no, you're okay. In person and in custody.
En persona y preso bajo la supervisión de Will Anderson.
We have received a copy of the complaint and waive its reading.
Anunciamos que se lea.
The address is correct
La dirección es correcta.
and Ms. Arias Vega is eligible for public defender services.
Y la señorita Arias Vega sí califica para los servicios del defensor público.
right, we do have certified Spanish interpreter Fred Svensson interpreting, and he's been sworn for the hearings at the jail this afternoon.
Y el intérprete Fred Svensson ha prestado juramento anteriormente.
I'll make findings of probable cause for the charges and get not guilty pleas entered.
Voy a hacer una declaración, entrar en el acto una declaración no culpable y determino que hay motivo fundado para los cargos.
I believe we have a victim on Zoom who wanted to make a statement.
Pienso que tenemos una víctima en Zoom que quiere hacer una declaración.
We would need to make sure that you speak in relatively short sentences and allow the interpreter to interpret.
Quisiéramos pedir entonces que usted, si quiere decir algo, va a hablar en frases son breves para permitir la interpretación.
So if you could identify yourself first, and then you can tell us what your thoughts are on bail or bond conditions.
Si se puede identificar primero y después expresar lo que usted opina sobre las condiciones de fianza.
Looks like maybe they were having an issue with the audio. I see they're.
Parece que tal vez tuvieron un problema con el audio. Veo que.
So something about trying to connect the audio and now they're muted.
Vi que estaban tratando de conectar su audio y ahora están en silencio.
If they could try clicking on the microphone icon to unmute.
Pueden intentar hacer clic en el icono abajo en la pantalla a la izquierda.
Yeah, it looks like now maybe they're connected to audio.
Parece que ahora están conectados con audio.
Mr. Canelon, can you hear us?
Señor Canelón, ¿nos escucha?
If you can hear us, give us a thumbs up.
Señor Canelón, si nos escucha, puede señalar con su dedo gordo, por favor.
All right, so I think the issue is on his end.
Pienso que entonces el asunto, el problema está ahí en el aparato suyo.
He could try logging off and logging back in, or just trying and calling the phone number.
Puede tratar de salir de la reunión y volver a entrar porque no has seleccionado audio.
We wouldn't necessarily need
O
video.
pudieras
The
llamar
app
al
is
número
the
de
issue.
teléfono de Zoom para conectarse por teléfono. No necesitamos su video realmente. Necesitamos su audio.
So you could try logging out of the session completely and logging back in again, or try calling on a phone.
Saliendo de la reunión por Zoom y entrando otra vez o llamando por teléfono.
This might take more than a few minutes. We have several other cases this afternoon. Maybe we want to take a brief adjournment and let the interpreter get on with the rest of their day and come back.
I have word from my victim witness coordinator that she's going to call him and we can put his statement into the record that way. If
All
that
right,
helps.
well, why don't we hear from the state since he can hear us, and then we'll hopefully have him on the phone to make a statement.
Many people have spoken without an interpreter. El secretario del tribunal dijo que se pudiera posponer la audiencia para permitir que el intérprete se vaya a su otra audiencia, y después la fiscal habló diciendo que pueden tener la coordinadora de víctimas y testigos a llamar al señor Canelón para que él pueda indicar en el acta su opinión sobre la fianza.
All right, what's the state's position on bail?
Muy bien, ¿qué es la posición del Estado sobre la fianza?
State is recommending a signature bond
El Estado recomienda una fianza de promesa
and condition of no acts or threats of violence towards Jorge LCG.
y con la condición de no tener ninguna amenazas de violencia o actos de violencia contra Jorge LSG.
Great, and I don't know if victim witness has been able to get Mr. Canelon in the interim.
Y no sé si el Departamento de Víctimas y Testigos se han podido contactar con el señor Canelón.
I have word that he wants contact with her.
Me han indicado que él desea tener contacto con ella.
But is otherwise in agreement with the state's recommendation.
Está de acuerdo con las recomendaciones del Estado. Aparte de eso.
All right, well, Mr. Canelon, I'm inclined to go along with that, and so you'd be allowed to have contact. Perhaps if that's good and you don't need to make any further statement, you could turn your video on and give us a thumbs up to let us know that it's okay.
Puesto a seguir esta condición de fianza. Si usted, señor Canelón, también está de acuerdo con eso, tal vez puede volver a prender su video y señalarnos con su dedo gordo que también estás de acuerdo, permitiendo el contacto. Gracias.
All right, I see a thumbs up, and I guess I take that as Mr. Canelon doesn't need to make any additional statement in light of the technological issues.
Dado los problemas técnicos, puedo notar que el señor Canelón nos ha señalado con su dedo gordo que está conforme con las condiciones de fianza y no hay necesidad de expresar alguna otra cosa.
I assume there's no objection from the defense.
No objection, Your Honor.
No hay ninguna cuestión de la defensa, ninguna objeción sucedería.
All right, so I'm going to order a signature bond with the condition you direct no acts or threats of violence towards Jorge LCG.
Entonces va a haber una fianza de promesa con la condición que usted no le haga amenazas o actos de violencia contra Jorge LCG.
And we are adjourned. Thank you.
Gracias.
Is that it for Fred then?
That's it.
All right, thank you, Fred.
Gasso? See you, Joe.
Oh.
All right, we'll call the state of Wisconsin versus Ugaso Ahmed, 26 CM 1606 appearances.
EDA Bridget Cook for the state.
Ugaso Ahmed appears in custody via Zoom by student attorney Caroline Scott under the supervision of attorney Anderson. Ms. Ahmed, do you have a copy of the complaint?
I do.
I think she said, yes, I do.
Yes, okay. And is the address on Fifth Street still the correct address for you?
Yes.
Okay. We have received a copy of the complaint and waive reading, and I don't have information right now about whether she's eligible for public defender services.
All right, so Ms. Ahmed, we'll make sure you get the public defender contact info. If you're unable to hire an attorney on your own, give them a call and see if you're eligible for a lawyer. I'll make findings of probable cause and are not guilty pleas to the charges. State's position on bail.
State is recommending $500 cash and no use or possession of alcohol. Ms. Ahmed was released on a signature bond on July 2nd with the condition to not drink alcohol, and here she was drunk and resisting arrest. The state believes that some cash is necessary given those facts.
And Ms. Scott?
Yes, Your Honor. We would be requesting a signature bond. Although this incident did happen in relatively quick succession from the other case, both were alcohol related offenses, and in addition, she was out on a signature bond in that previous case. And sorry, one moment. And okay, never mind. Yeah, based on the offense and based on the offense, we'd be requesting a signature bond or a much more modest cash.
All right. If we were just here on the violation of the no drink condition, I think it'd be a different issue. She's non-compliant with law enforcement and gets arrested, cuffed, and then apparently tries to take out through the side door at the police station. That's not consistent with somebody who's going to show up without some cash on the line. I'm going to set it at $300 in order that she not possess or consume any alcohol, and we'll be adjourned.
All right, ready for Nelson? Yeah. Nelson.
We'll call the state of Wisconsin versus Camary Nelson. It's 26 CM 1613 appearances.
EDA Bridget Cook for the state.
Camary Nelson appears in person in custody by student attorney Caroline Scott under the supervision of attorney attorney Anderson, sorry. We have received a copy of the complaint and waive its reading. The address is correct, and Ms. Nelson is eligible for public defender services.
Right, I'll make finding of probable cause and are not guilty pleas to the charges and state's position on bail.
State is recommending a signature bond with conditions of no contact with Rajana T, that's RAJANA, a ban from the 100 block of Milky Way in Madison, and no use or possession of alcohol.
Right, any objections?
Okay, no objections, Your Honor.
Okay, I'll order a signature bond, conditional be a no contact direct or indirect with Rajana T, a ban from the 100 block of Milky Way in Madison, and that you not possess or consume alcohol, and we'll be adjourned.
Bridget sent us next.
All right, we'll go on the record in the state of Wisconsin versus Alicia Richardson, 26 CM 1620 appearances.
DA Bridget Cook for the state.
Alicia Richardson appears in person in custody by student attorney Caroline Scott under the supervision of attorney Anderson. We have received a copy of the complaint and waive its reading. The address on the complaint is correct, and Ms. Richardson is not eligible for public defender services.
Okay, Ms. Richardson, if you're not able to hire an attorney on your own, you can reapply with the public defender's office or apply for a county appointed attorney. The deputy's giving you the public defender info in case you need it. We'll make findings of probable cause and are not guilty pleas. State's position on bail.
State is recommending a signature bond with the standard non-monetary conditions.
And there's no objection.
No objection.
Right, we'll order a signature bond with the statutory conditions and we'll be adjourned. Means you're getting out, you just have to sign your bond and then you got to make your court dates, not pick up any new charges, and not harass or intimidate any of the witnesses in the case. Those are the standard conditions. Yeah. You're welcome.
Thanks. Early.
Go on the record in the state of Wisconsin versus Julie Hurley, 26 CM 1611 appearances.
ADA Bridget Cook for the state.
Oh, okay. Julie Hurley appears in person in custody by student attorney Caroline Scott under the supervision of attorney Anderson. We have received a copy of the complaint and waive its reading. The address is correct, and she is eligible for public defender services.
Great, I'll make findings of probable cause. We'll get not guilty pleas entered to the charges. The PSA report recommends cash bail. State's position on bail.
State is recommending a signature bond and no contact with Gregory H.
Right, any objections?
No objections.
Right, well, we certainly have some reluctance with that, but it's a joint recommendation and they know the case better than I do. I'll order a signature bond, conditional be a no contact direct or indirect with Gregory H. I don't think you want to be picking up any additional cases or missing court because the PSA is not very favorable.
Absolutely.
Yeah. All right, we are adjourned.
Bates is next, William Bates. Here, Joe.
Yeah.
Go on the record in the state of Wisconsin versus William Bates, it's 26 CM 1608 appearances.
ADA Bridget Cook for the state.
William Bates appears in custody via Zoom by student attorney Caroline Scott under the supervision of attorney Anderson. Mr. Bates, have you received a copy of the complaint?
Yes, I did.
Okay. And the address on there is correct?
Yes, it is.
Okay, and he is eligible for public defender representation.
All right, I'll make a finding of probable cause for the charges that apply to Mr. Bates. Get not guilty, pleas entered, state's position on bail.
State is recommending a signature bond, no contact with Speed B, a ban from the State Street area per the ban map, and no consumption or possession of alcohol.
Any objections?
No objections.
Okay, we'll order a signature bond, conditional be a no contact direct or indirect with Speed B, a ban from the State Street Langdon area per the ban map, and that you not possess or consume any alcohol, and will be adjourned.
Tyson Christian next.
Christian?
We'll go on the record in the state of Wisconsin versus Tyson Christian. It's 26 CM 1610 appearances.
ADA Bridget Cook for the state.
Tyson Christian appears in person in custody by student attorney Caroline Scott under the supervision of attorney Anderson. We have received a copy of the complaint and waive its reading. And is the social justice?
Yes.
Best address for him is the social justice center, which don't think is the one that's listed on the complaint. So I'm trying to grab it quick
I
here.
know that one off the top of my head. Maybe the clerk does.
Oh, I think it is the same one that's on the complaint. Sorry, it's the 1202 Williamson Street. It's suite 106 instead of apartment, but otherwise it's correct. And he is eligible for public defender services.
Right, I'll make a finding of probable cause. We'll get a not guilty plea entered, state's position on bail.
State is recommending a signature bond with conditions of a ban from the Capitol Square, no use or possession of alcohol, and no contact with Kennedy P.
Any objections?
No objections.
Okay, or signature bond condition will be a ban from the Capitol Square per the ban map. The deputies handed you that, so pay attention to that because obviously all the cops know who's not supposed to be in those areas.
Don't talk about the fact that you're.
Well, you may want to talk to your lawyer there.
The officer that arrested me, I was singing cadence with a friend, my friend went to meet
Okay,
the one.
you probably don't want to talk about the facts of the case without talking to your lawyer first because it's all being recorded. Mr.
This isn't
Christian.
saying why I was charged with disorder in the first place.
It does.
No, it doesn't. It tells me where. Show me one place where it says what I did something disorderly.
Okay, then when you get a
It's
lawyer
totally
appointed, you
dismissed.
can file a motion to have the case dismissed, okay?
I was this close to going to a mental health board, but you know what? I'm not signing the signature. I'm just ready to do my time.
That's your choice.
Okay.
Okay, well, I'll adopt the conditions that the state requests in order of signature bond, and if Mr. Christian changes his mind and decides to sign the bond, he can be released. If not, he'll be held.
All I did is.
Well, you read the facts. They allege that you were threatening to shoot people, so I don't know whether that's true or not. But okay, we are adjourned. Good luck, Mr. Christian.
Everybody knows what the saying is. Somebody I had no contact with a few years ago called the police and lied, and I went to jail over a lie. I don't own firearms, I have never owned it. You know, wasn't a good speaking, just not my time. I was moving, go ahead, I got a.
Galligan is next. Galligan.
Right, we'll call the state of Wisconsin versus DeAndre Galligan. It's 26 CM 1616 appearances.
ADA Bridget Cook for the state.
DeAndre Galligan appears in person in custody by student attorney Caroline Scott under the supervision of attorney Anderson. We have received a copy of the complaint and waive its reading. And that's the best address for you. Okay, the address is correct, and he is eligible for public defender services.
Right, I'll make findings of probable cause and are not guilty, please, state's position on bail.
State is recommending a signature bond with conditions that he not have contact with Lindsay S. That's LINDSEY, and a ban from the 200 block of West Street in Dane County.
West Street where?
It says in Dane County. I can check the party address 1 second.
All right, well, any objection to the requested conditions?
Yes, Your Honor, that is where Mr. Galligan resides, although, well, I don't know, it's 120 West Street is the address, so I don't know if
I
that's
think,
the.
Village
Yes, that's
Dane.
correct.
Okay,
With the people, please.
that's where he resides with his children, and his fiance is the alleged victim here. So we would ask for a no threats or acts of violence amendment to those conditions.
Okay, and maybe I misheard. I thought the state asked for the 200 block of West Street.
Yeah.
But a no contact with the victim. Is it supposed to be the 100 block of West Street? And maybe there was a typo in the notes?
I believe so, Your Honor. Let me double check the complaint. Yes, I just got word that it should be the 100 block.
All right, makes sense. I assume he knows where he was residing. Um. So has there been any update from the victim on their thoughts? Looks like the victim enforces 72 hour no contact.
The victim is in agreement with the request for no contact, and this is Act 3 eligible, I believe. So for
It
her
is.
protection, we would ask for that.
Any response from the defense?
Nothing further, Your Honor.
It's an Act 3 eligible offense. The victim doesn't want contact. They could attach a copy of the criminal complaint and get a restraining order against you granted for up to 14 days before an injunction hearing anyways. I'm inclined to order the no contact as a condition of the signature bond with Lindsay S. and a ban from the 100 block of West Street. Bond can be modified, have your lawyer file a motion, and if the judge sees it different, it can get modified. If you do need to get any items from the residents, just contact the sheriff's department to arrange for a preserve the peace to get items. Don't have any contact with the victim or go to the residence without the presence of law enforcement, okay? And do you have any thought as to where you might be able to get mail in the interim? Okay, when you figure that out, let your lawyer know so they can update the court so you don't miss future notices. You can always sign up for text message reminders, and that's something you can do when you sign your bond. All right, we are adjourned.
Yeah, that's right. Riviera's next.
Which one?
Del Valle.
Oh. Yeah. Great, we'll go on the record in the state of Wisconsin versus Felix Del Valle. It's 26 CF 1542 appearances.
Bridget Cook for the state.
Felix Del Valle Rivera appears in person in custody by student attorney Caroline Scott under the supervision of attorney Anderson. The address on the complaint is correct. We've received a copy of the complaint and waive its reading, and Mr. Del Valle is eligible for public defender services.
All right, I'll make findings of probable cause, enter not guilty pleas to the misdemeanors, state's position on bail.
State is recommending $5,000 cash, no operation of a motor vehicle, no consumption or possession of alcohol, no contact with Victoria S., and a ban from Meritor Hospital unless there's a legitimate medical purpose. This is Mr. Del Valle's third felony case, including another pending OWI fourth, and he has violated conditions of those other cases. State believes cash is necessary at this point.
Ms. Scott?
Your Honor, we would be asking for a signature bond here. Mr. Del Valle has had no issues with appearing on his signature bonds in the past. And in addition, and although these are serious offenses, his appearance is, the court can feel assured of his appearance. In addition, his roommate just passed away, and he has been dealing with that, and he is moving on August 7th, so he needs to, he's gonna need to deal with that. But yeah, due to his, he also receives SSI, so any high amount of cash bail would be prohibited for him. So we'd be asking for a much lower amount of cash or a signature bond.
All right. I see it as a cash bail case. He had a felony level OWI. He's now got one where he's looking at presumptive prison. In its case number 3, there was some resistive behavior as well. It looks like he's made all his other court dates. I haven't heard a history of missing court that's in his favor. I'm willing to set it at a lesser amount. I'll set it at $1,500. I will order that you just not operate a motor vehicle at all, that you not possess or consume any alcohol at all, that you be banned from Meritor Hospital unless it's for a legitimate emergency, and a no contact direct or indirect with Victoria S. What about time limits for the preliminary hearing?
We would like to keep the time limits in place.
Okay, we are adjourned.
Jones is next.
Right, we'll call the state of Wisconsin versus James Jones. That's 26 CF 1532 and 26 CM 1609. And then we have a bail hearing in 26 CM 1176 appearances.
ADA Bridget Cook for the state.
James Jones appears in person in custody by student attorney Caroline Scott under the supervision of attorney Anderson. We've received a copy of the complaint and waive their reading. And Mr. Jones is sending your best address. The job center, Gaber, the job center is a good address for you to get your mail. You want to get your mail at the Beacon? Okay, can we change his address to the Beacon, please? And my understanding is that Mr. Jones does not want public defender representation. Okay.
Okay, I'm gonna have the deputy give you the public defender info just in case you change your mind. You're certainly free to hire an attorney of your own after today if you'd like. I'll make findings of probable cause in the new cases. And we do need to address bail in the older case. What's the state's position on bail?
Sorry, one moment, please. I see. Okay. In 26 CM 1609, the state is recommending $500. He failed to appear on July 8th in another pending case. And conditions of no contact with speed B, a ban from the State Street area, and no alcohol. In 26 CM 1176, state is recommending $500, no contact with HCB or WJR, and no alcohol. And then in the felony case, the state is recommending, it looks like it was he already had an IA, but the state is recommending.
I think it's a reissued complaint.
Okay,
So he
that makes
probably
sense.
did have an IA in bail and then for whatever reason it got dismissed and reissued.
Okay. At this point, the state is recommending for that case, $1,000 cash, no use or possession of financial documents or instruments not in his own name.
Right. Scott?
Yes, Your Honor. Mr. Jones, to address the felony bail, had $200 set in that case previously, and the officer did not appear at court. So that we would be requesting that not be raised because that had nothing to do with Mr. Jones. In addition, he informed me that he missed court for as it relates to his bail hearing today. He missed court because he wasn't aware that he had court that day. And so we'd be asking that the signature bond be reinstated on that case. And on the new misdemeanor cases, we would also be asking for a signature bond. Mr. Jones is indigent, and any amount of high cash bail would mean that he's just going to sit for a long time. And on these new cases, they're misdemeanor cases with not a high level of exposure.
All right. And any response from the state?
Given the number of cases and the missed appearance, even if he states he was not there, I think the cash requests are appropriate.
All right. Well, I think there's a need for cash bail. He's picked up 3 cases. He missed a court date. The clerk popped me up. He had notice in hand of that missed court date, so he should have known about it. That said, I don't see an increase in the bail, and 26 CF 1532 is fair. When the state couldn't proceed, had to dismiss the case, and he was on a $200 bail. I'll order that. I'll order that you not use any financial documents or instruments that are not lawfully in your own name. In the 26 CM 1176 case, I think $200 bail is sufficient there with the prior conditions. And then in 26 CM 1609. I'll set $200 cash bail. Order a ban from the State Street Langdon area. They're gonna give you the ban map, so make sure you pay close attention to that. That you not possess or consume any alcohol. And I thought maybe I'd heard initials that you wanted on no contact in that case, but I couldn't catch what they were. Did I mishear that?
1608.
1609, yeah.
Sorry, 609. Yes, no contact with speed B.
Oh, speed B,
SPED.
not initials. All right, I will order the no contact director and direct with speed B as well. And does he want a preliminary hearing again in 20 days on the felony case?
So you have 20 days. Right. We'll keep time.
Okay, sounds good. We are adjourned.
Okay, this one's Jordan is next. Oh, after she had it. Jordan.
Called the state of Wisconsin versus Liddell Jordan. It's 26 CF 1535 appearances.
DA Bridget Cook for the state.
Liddell Jordan appears in person in custody by student attorney Caroline Scott under the supervision of attorney Anderson. We have received a copy of the complaint and waive its reading. And the address is correct, and Mr. Jordan is eligible for public defender services.
I'll make a finding of probable cause, state's position on bail.
State is recommending $1,000 cash, no contact with Yolanda R., and a ban from the 2400 block of Chalet Gardens in Fitchburg. Mr. Jordan posted $1,000 cash earlier this year. He has multiple bench warrants from 2025. And I believe that this is the same victim as in previous cases.
And the defense position?
Yes, Your Honor. Mr. Jordan has not had any issues with appearing in the past. And given that he is public defender eligible and the job center is his best address, he's indigent. So I think $1,000 is too high for this situation. We'd be asking for a signature bond. And it seems like based on the facts of this situation, there's some kind of an ongoing relationship here. It was alleged that they were spending some time together before this happened. So, and he said that he was there to collect his belongings. So it seems like, based on those facts, that a signature bond would be appropriate.
All right, let me take a closer look at things. Any response from the state?
I'm not sure exactly what the bench warrants were for, but I would just highlight that there were several in 2025.
Well, so he had $1,000 cash bail. He was ordered not to have any contact with the victim. And there's been a number of failures to appear. His version is that they had some contact previous to this and thought maybe he would be okay in violating the conditions. Obviously, the victim didn't agree with that. I'm not sure that she confirms his statement, though, in regards to having consensual contact a week or so prior.
I think there's
I don't have anything outside of the complaint on that, except for that she was the one who called 911.
Well, she says that he pressures her and scares her to allow him to be around. Yeah, I think $1,000 is about the minimum here. He's already on $1,000 cash bail. He's violating the bail condition. And has a history of missing court. I'll order that along with a no contact direct with Yolanda R. Again, make it clear, doesn't matter if the victim reaches out to you, you can't have contact with this person. You're just going to continue to get in trouble. The bail can be forfeited. The charges can get more serious. You'd have to have a judge modify the bail, and you can certainly have your lawyer file motions to do that. I'll also order a ban from the 2400 block of Chalet Gardens. And should we just get a prelim scheduled in the next 10 days?
Yes, Your Honor.
Okay, we are adjourned.
Who is this?
Okay, we'll go on the record, the state of Wisconsin versus Jakari Hooper. It's 26 CF 1541 appearances.
Bridget Cook for the state.
Jakari Hooper appears in person in custody by student attorney Caroline Scott under the supervision of attorney Anderson. We've received a copy of the complaint and waive its reading. The address on the complaint is correct, and Mr. Hooper is eligible for public defender representation.
All right, I'll make findings of probable cause, get not guilty, please enter to the misdemeanors, state's position on bail.
State is recommending $500 cash and a ban from tobacco deals store. Mr. Hooper was on bond for an armed robbery at the time of this offense, and some cash seems necessary to ensure that he does not continue to commit new crimes.
Scott?
Yeah, we'd be asking for a signature bond, Your Honor. Although he was out on bond, signature bond at the time of this offense, it happened very shortly afterwards, and then he has been for several months has not had any contact with law enforcement. He has no other criminal history, and he's lived in Wisconsin for at least 6 years. And he lives with his family, so he has ties to the community. He also has a job interview scheduled for this week, so there's reason to believe that he is seeking some stability in his life and would appear in court. So we'd be requesting a signature bond.
All right, well, it's concerning. He was out on a very serious charge and he's picked up another charge, a much less serious charge. He hasn't missed court. Apparently got a signature bond on that very serious charge. I guess I don't see this case as the one that's changing the analysis and whether he's going to appear or not. If it were an Act 3 offense, it would probably be a very different story, given the serious charge you're out on bail on. I'm going to give you another signature bond, order a ban from all tobacco deals locations. You don't want to be picking up any more cases, Mr. Hooper. Cash bail may be in the future, okay? Sure. What about time limits?
We will keep them.
Okay.
And I guess I would note that Mr. Hooper has a prelim scheduled already on August 6th. That's outside the 20-day time limits. I can set this for prelim at the same time, or I can set it for status conference concurrent with that.
I would say it's outside the time limits for
It's
this.
in August, yeah.
Let's just wait and set for. So
You can do them both at once.
yeah, waive the time limits, but set for a prelim at the same time as the one that's already scheduled, please, right?
Thank you for that.
Makes sense. We are adjourned.
This one's. The third one's that.